Welcome to our new video. Today, we're going to break down some of the most important trademark statuses in India that you must understand before or after filing your trademark application. Whether your status shows refused, advertised before accepted, or opposed, I'll explain what each of these mean, what steps you need to take, and how to avoid potential pitfalls. Let's dive right into it. Question 111. What steps should an applicant take if their trademark application status shows refused? And how can they address the objections raised by the trademark examiner to resolve the refusal? Answer. When your trademark application status shows refused, it means the trademark examiner has determined that your trademark does not meet the necessary legal requirements for registration under the Trademark Act 1999. The first step is to carefully review the examination report or the official communication from the Trademark Registry to understand the specific reasons for the refusal, which may include issues like similarity to an existing trademark, lack of distinctiveness, or the trademark being deceptively similar to another mark. If you believe the refusal is incorrect or can be overcome, you can file a response addressing the objections raised, such as providing evidence of distinctiveness, modifying the trademark to resolve similarities, or presenting legal arguments to counter the examiner's decision. If the issues cannot be resolved through a response, you can request a hearing with the examiner to further clarify your position. Should the refusal remain after the hearing, you have the option to appeal the decision to the Intellectual Property Appellate Board, IPAB. Alternatively, if the refusal is based on insurmountable objections, you may need to consider revising your trademark and submitting a new application. It is essential to act within the given timeframes, typically 30 days, to avoid abandonment of the application. Question 112. What does the advertised before accepted status indicate in the trademark registration process, and what are the subsequent steps if no opposition is filed within the stipulated period? Answer. If any trademark is added to the Trademarks Journal and advertised there, the status of the trademark application is advertised before accepted. Any third party can oppose such trademark application within 4 months of being advertised. If no opposition is filed within this period, the registrar reviews the application again and formally accepts the trademark. Once accepted, the status changes to advertised and accepted. After completing the final registration process and issuing the certificate, the status is updated to registered. Question 113. What is the significance of advertising a trademark in the Trademark Journal for a period of 4 months? And how does this process provide an opportunity for third parties to oppose the registration? Answer. The purpose behind the advertisement of a trademark in the Trademark Journal for a period of 4 months is to provide a public notice and an opportunity for third parties, such as other trademark owners or interested individuals, to raise any objections or oppose the registration of the trademark if they believe it conflicts with their existing rights. Here's why this step is important. 1. Public awareness. The advertisement serves as a public announcement that a trademark application has been filed and is moving forward. It allows businesses, individuals, and other stakeholders to become aware of new trademarks that are being registered. 2. Opportunity for opposition. The 4-month period gives any interested party the opportunity to file an opposition against the trademark registration if they believe it may infringe on their own trademark or cause confusion in the marketplace. 3. Protecting existing trademark owners. The advertisement period acts as a protective mechanism for existing trademark holders. If another business files for a trademark that is too similar to theirs, they can use the opposition process to prevent the new trademark from being registered. 4. Transparency and fairness. The Trademark Journal is a tool for transparency in the trademark registration process. It ensures that the process is open and fair, allowing anyone with a legitimate concern about the trademark to voice their opposition before it is granted exclusive rights. And 5. Ensuring legal certainty. The publication also allows the public and other businesses to confirm whether a mark has been applied for or registered. This transparency reduces the chance of future legal disputes regarding trademark rights, as everyone can see which marks are in the process of registration. 6. Legal standing. If an opposition is filed during this period and is successful, the application may be rejected or amended, preventing the potential for legal conflicts in the future once the trademark is officially registered. Question 114. What is the role of the Trademark Journal published by the Indian Trademarks Office, and how does it ensure transparency and fairness in the trademark registration process? Answer. The Indian Trademarks Office, under the Controller General of Patents, Designs and Trademarks, CGP-DTM, Ministry of Commerce and Industry, is responsible for publishing the Trademark Journal of India. This journal serves as an official public record that contains details of new trademark applications that have been examined and are ready for advertisement, accepted trademarks that may proceed to registration, oppositions filed against advertised trademarks, decisions on trademark disputes or hearings. The Trademark Journal is published weekly and allows the public to review trademarks before they are officially registered. If anyone believes that a published trademark conflicts with their existing rights, they can file an opposition within 4 months from the date of advertisement. This process ensures transparency and fairness in trademark registration, preventing conflicts and protecting intellectual property rights. Question 115. What does the opposed status indicate in the trademark application process? And what are the possible outcomes if a third party successfully files an opposition? Answer. When a third party files an opposition against a trademark application within 4 months from the date of its advertisement in the Trademarks Journal, the application status changes to opposed. A trademark opposition is typically filed if the opposing party believes that the applied trademark is similar or identical to an existing registered trademark, may cause confusion among consumers, is descriptive, generic, or misleading in nature, violates any legal provisions under the Trademarks Act 1999. Once opposed, the application enters the opposition proceedings, where both parties, the applicant and the opponent, must submit their arguments and evidence before the trademark registrar. The decision on whether to register or reject the trademark depends on the outcome of these proceedings. If the opposition is successfully defended, the trademark proceeds toward registration. However, if the opposition is upheld, the application may be refused or abandoned. If you want to register your brand name, logo, or tagline and legally secure your identity, don't wait. Get expert help with the entire trademark registration process. Contact VMK Professionals, your trusted legal and business partner, to ensure your brand is protected under the law. Visit www.vmkpros.com and get started today. That's it for today's video. We hope you learned something new about trademark statuses and how to handle objections or refusals in India. Don't forget to hit the like button, subscribe to our channel, and turn on notifications so you don't miss any future updates on trademark and legal matters. See you in the next one. Thank you.